Sansan, you've been quite vocal about this particular topic, and I've seen you posting some things on social media as well. Now, the big issue which the governors are using to base their discussion on is the sovereignty of the people, Article 1.4. The sovereign power of the people is exercised at the national and county level. So some are saying this then makes governors effectively county presidents, but others are saying no, this makes governors simply county CEOs. What is your view?
I was looking for a better word so that I don't sound offensive, but I'm not able to capture it. So what I can say is that that is delusional, in the sense that it's not, you can't reference it in the Constitution. What governors are raising, they're raising a political controversy. It's not a legal controversy. A legal controversy emerges when the law specifically states as follows, but then there is some dispute as to the proper interpretation or application of that law. You get, if you look at the Constitution, the design of the Constitution, county governments or governors, they are not heads of government. They are heads of county government. There's a clear distinction in law. The heads of government is the presidency, the president who is the head of the executive wing of government, and under Article 145 of the Constitution, under Article 143 of the Constitution, he is immune from civil and criminal proceedings. The second head of government is the judiciary, and the Chief Justice and the judiciary. And if you look at Article 160, sub-Article 5, the judiciary is immune from any kind of proceedings for work done within the courtroom. You get. Then the third arm of government is the legislature. If you look at Article 117 of the Constitution, Parliament has some parliamentary privileges and immunities for work done within the presence of Parliament. The Constitution ends it there. If you look at the design of the county governments, look at Article 196, for instance. It is the national parliament, it's it's Parliament, the National Assembly, that is mandated to make laws that may provide for county assembly immunity. So even the immunity of the county assembly during the debate, and that's a practical sense issue, because then they have some mandate, there's some oversight mandate, just like the National Assembly. They may need to enjoy some privileges in the conduct of their functions. And even that privilege is circumscribed by what Parliament thinks is necessary. So it's not true for Council of Governors to call a press conference and tell Kenyans that they demand immunity based on Article 1. That is what I've been describing as a chaotic expansion of mandate, reassigning powers that do not belong to them, and entrenching impunity without knowing, or maybe knowing so.
Okay.
Yes.
So to you, when they say that devolution is in danger, when governors are hauled to court and you see them in handcuffs and that sort of thing, you don't buy that argument?
Devolution is not in danger because the governor is in charge. You see, first of all, governors and all public and state officers, they're required by law to act in good faith, because the positions they hold is a position of public trust. And if you do something that is inconsistent with public trust, acting in good faith, then you'll be held to account. The design of our Constitution requires transparency, accountability, and openness in the implementation of your mandate. So if you do anything that blurs the line or maybe exceeds your mandate, then of course the natural reaction, the natural legal reaction is to bring you back to space within your line. What has been committed to county governments is to ensure that there's service delivery to the counties, to ensure that there is effective public participation in the counties, to ensure that people that live in those counties can really feel the benefit of a devolved system of government. It is not a system that is intended to exclude or immune or to remove from accountability
sort of the holders of
indeed, and tell Kenyans, not even the president, for sure, is completely immune. If you look at
I want to stop you there because that's something that I want to push you a little bit about. Well, we carry on with our discussion. We're talking about gubernatorial immunity or impunity, and Steve Ogolla, an advocate of the High Court, was just giving us what the law says about this. But what we are curious to find out is, so in the unlikely event that this conversation then moves forward, what sort of amendments would need to happen for governors to get what they are calling for? Because we know that, for example, in Nigeria, Senate, I think, but more importantly, the governors there have some sort of immunity.
No, that would be an act in futility, because it would significantly affect or alter the present constitutional arrangement of powers and functions. If you propose an amendment that tinkers with the basic design or the basic structure of the Constitution, then that amendment may itself be deemed to be unconstitutional. Let me explain this in this manner. What must be consistent with governors getting immunity? It means that county governments are autonomous. They must be autonomous if you want to give them that kind of immunity. And if they're autonomous, then they must have their own regional judiciaries. You get appointed, and they must, in terms of revenue collection, they must not depend on the national government to get revenue. So it's a very complex argument. It's not simple as they want to put it. They want to make us believe that because they want immunity, we can just amend the Constitution. For now, there is not a clear provision in law that can point towards giving them immunity. And it's by design. If you look at the entire Constitution, the design of the Constitution recognizes that powers at the powers of the executive need to be divided, dispersed, and separated and curtailed at a certain level, so that what the president is sharing with the governor is distinct. In terms of the functions of the governor, they are distinct functions. His powers are distinct, but that doesn't make him an autonomous head of government. You get? That is the design of the Constitution. That is why, even within the counties, if there is a legal controversy, the counties rely on the judiciary that is a national structure, falls within the national government. If there is a controversy between the law in terms of conflict of laws under Article 181 of the Constitution, the national laws made by Parliament override county laws. So the design of the Constitution does not permit immunity of governors, and if you wanted
unless you make some very wide-ranging changes,
you will have to alter what constitutional law has described as the basic structure of the Constitution. That's a very significant step that would then divide Kenya into 47 autonomous regions, but we are held together at the national level for purposes of policy formulation, uniformity of policy formulation, economic policy, monetary policy, and then foreign policy.
Steve, before...
So it's not possible. I don't see that. I don't see us getting there. That's a question that would require a referendum, and I don't think Kenyans would approve something like that.
Before we took the break, you talked about the president's immunity also having particular limits.
Yes.
And I know the president should be, while in office, shielded from criminal liability and civil liability as well. So where are the limits?
Well, you see, the limits are founded in the fact that if you read the Constitution in totality, the design of the Constitution is transparency, accountability, and inclusiveness. Transparency means that even the president, in terms of the exercise of the executive function, he must do so in an open and in an open and verifiable manner. In terms of accountability means that there are some actions that the Constitution has committed specifically to the president. For instance, appointment of commissioners. You get constitutional commissioners and independent office holders. Upon the vetting and approval by the selection panels, the president has a constitutional mandate, for instance, to appoint new commissioners, let's say that of IBC. If the president refuses or neglects to appoint commissioners that have been interviewed, in a competitive, open, and transparent process, of course, someone can go to court and point the court in what is called judicial review proceedings, tell the court, listen, the president has an unqualified obligation to perform this function because this function is committed to him. He has not done so, and therefore crippling the entire setup, the entire constitutional setup. Of course, the courts will intervene. Nobody can come and say, we want to raise objection under Article 143 that the president enjoys civil immunity, immunity from civil proceedings. That is one example where the powers of the president is also significantly curtailed. The other aspect is that the constitutional design is intended to move us from governance based on passion and discretion and raw power to a consultative, inclusive, deliberative approach to government. If the president falsifies that aspect, of course, it's open to the court to demarcate the boundary within which the president can operate and then to exclude as illegal and unconstitutional actions that fall outside the boundary that has been framed for him.
Fair enough.
So yes, it's possible that the president's action can be challenged in court.
There is a school of thought that the governors, despite what many Kenyans may feel are wrong about their call for immunity, said that the governors have a point. That a governor, just like a CS, oversees a particular jurisdiction. And when there's a problem within that jurisdiction, if the governor should be held accountable, then why not the CS? So how come it has now become easy in 2018 to see a governor being hauled into some sort of van and put handcuffs on, but not for a CS?
But what about what I don't get is the foundation of that argument, because CS can be held into court. They can be taken to court. There is no immunity for a CS not to be taken.
They feel that the treatment is not fair.
No,
it's
well, that's anybody can feel anyhow. Sorry, the governors. But the thing is this, Msega. Governors are raising a legitimate point. This is not just to undermine the concern they're raising, so that we can find ways of dealing with those concerns without necessarily granting them immunity.
Okay.
What they're saying is this, and understand them clearly, there are some functions that have been committed to the governor, for which they hold political accountability, whether they act in good faith or not. If the county executive committee members, the CEC, or what we like to call the county minister, offends the law, of course you'll inquire into the role of the governor in terms of critical oversight or supervision of his ministers. If there is a critical failure on his part, then he might be held to political accountability. The question that they're raising, which you must now debate and agonize over, and then begin to organize that space to accommodate their interests, they are saying that, listen, can the ODPP, exercise some level of sound prosecutorial judgment? Can you just, when you're evaluating evidence available, other than evaluating the evidence, the falsification of the law, can you also look at the aspect of political accountability? Are you really sure that the governor, being the head of the county government, was intimately involved in this process? You get? So that I think there has to be some level of restraint, and that must be there. It must be debated. It shouldn't be open to the ODPP on every other issue, because otherwise it will be possible to arraign governors on almost every issue, because you see,
from every county.
From every county. We are still struggling with animating devolution.
Okay.
So I think the onus falls upon, or the ball falls in the court of the ODPP to exercise a level of restraint. You get? But when the ODPP makes the decision to prosecute, you must support him.
You must support him.
That is the kind of collaboration. Otherwise, then, when governors develop an overly cautious approach to work, then you can see that the ripple effect would be service delivery will be curtailed in a manner that is not beneficial to the members of that county.
Okay.
That is the political question they're raising, but the answer is not in immunity. The answer is in building bridges, collaboration, consultation with critical stakeholders, also bringing clarity on demarcation of powers and responsibilities. I think in the next in the next Council of Governors conference, that issue must be isolated for discussion, so that we know how can we demarcate, powers of this in terms of accountability. Since governors can be prosecuted, how can we demarcate the roles of governors and make sure that these CECs the buck truly stops with them, and governors only come in at the level of supervision and for political accountability.
Fair enough.
That way, it will be easy to cover them without granting them immunity.
I think in a nutshell, the Council of Governors asking a good question, but the answer might not be where sort of they are chasing after.
Yes.
And Steve Ogolla, thank you so much for joining me today, and an advocate of the High Court for this particular discussion. We also were expecting Peter Wanyama, a lawyer with the Council of Governors. He has not shown up for this particular discussion.